We always think of the CEO as the one in charge, the person calling all the shots. But what if I told you that behind the scenes, there's a hidden rule book that dictates who really has the power? Well, today, we're going to pull back that curtain and figure out who's actually running the show. So who does run a company? Is it the board? The shareholders? The CEO? The truth is, it's way more complicated than you think. It's this constant, sometimes messy, tug of war that's all laid out in a document that, let's be honest, most people have never even heard of, let alone read. Okay, so here's our game plan. First, we're going to dig into the company's secret rulebook. Then, we'll get to the heart of it. Who's really in charge? After that, we'll look at this bizarre contract that you literally can't refuse. We'll also see how you can change a company's core DNA. And finally, we'll wrap up by looking at the power struggles that the law still hasn't figured out. All right, let's start at the very beginning, with the foundation of it all, the company's secret rulebook. And to do that, we need to get our heads around something called the Articles of Association. Think of the Articles of Association as the user manual for a company. Or maybe a better way to put it is, it's like the rulebook for a sports team. It lays out in black and white exactly how power is split between the owners, that's the shareholders, and the people running the day-to-day, the board of directors. It's the document that answers the biggest question of all: who gets to decide what? Now, these rules haven't just appeared out of thin air. They've evolved. Before 2009, pretty much everyone used this one-size-fits-all rulebook called Table A. But since then, things have gotten a bit more sophisticated with what we call model articles. Now we have separate versions for private and public companies. And while they're technically optional, in reality, they've become the default blueprint for how almost every new company in the UK is run. And this rulebook is what sets the stage for the main event, the core power struggle inside every single company, that constant push and pull between the board of directors and the shareholders. So how does this power split actually work? Well, under these model articles, the board of directors gets its main power from Article 3. This basically says, you guys manage the day-to-day business. But, and this is a big but, the shareholders have a trump card. Article 4 gives them a reserve power. This means they can step in and tell the board what to do, but only if they can pass something called a special resolution. And to do that, they need to get a whopping 75% of the votes. This really drives home just how much independence the board has. There's this famous quote from a 1974 court case that makes it crystal clear. Directors can run the company how they see fit, even if shareholders hate it. The shareholders can't just barge in and interfere. They have to use those official channels, like that 75% vote we just talked about. This gives the board some serious independent authority. But don't go thinking the shareholders are powerless. They hold some absolute trump cards. The biggest one? The nuclear option, really. It's the right to remove a director under Section 168 of the Companies Act. All it takes is a simple majority, just over 50% of the vote, and they can fire a director. For any reason, no explanation needed. On top of that, they can change the entire rule book with that 75% vote. These powers are the ultimate check on the board's authority. Oh, and here's a really crucial detail that often gets missed. The board controls the cash flow. Even if the company is raking in massive profits, shareholders don't see a dime of it as a dividend unless the board recommends it first. This gives the directors huge financial leverage over the very people who own the company. Okay, get ready for a fascinating legal twist. That rulebook we've been talking about, the Articles of Association, it's not just a list of rules. It's a legally binding contract. A contract that you're automatically signed up to the second you become a shareholder. This all comes down to one tiny but incredibly powerful piece of law, Section 33 of the Companies Act 2006. This is the legal magic wand that turns the company's rulebook into a contract that binds the company and every single one of its members, whether they like it or not. But this is a seriously weird kind of contract. I mean, think about it. It can be changed even if you totally disagree, as long as 75% of the shareholders vote for it. If you buy shares, you're automatically bound by it without signing a single thing. This crazy flexibility is actually what makes the stock market work. Everyone knows the exact set of rules they're buying into. But this strange contract has created a century-long legal headache. The big question is, can shareholders use it to sue each other directly? Well, the courts have given completely opposite answers. Back in 1909, a case called Salmon v. Quinn and Axton said no, only the company itself can enforce the rules. But then, 50 years later, Rayfield v. Hands said actually, yes, they can. The result? Total legal uncertainty that still hasn't been fixed. So this leads us to a really important question. If this rulebook is a contract, but a contract that can be changed, how in the world does that happen? How does a company actually go about rewriting its own DNA? The magic number, as we've seen, is 75%. To change the articles, the shareholders have to pass what's called a special resolution. As soon as that 75% threshold is hit, the change is locked in, and it binds everyone, even the minority who voted against it. But there's a catch. This power isn't unlimited. A really important case from way back in 1900, Allen v. Gold Reefs, put a critical limit on it. It says that the power to change the rules has to be used in good faith, or bona fide, for the benefit of the company as a whole. This is supposed to be the safety net that protects the minority shareholders from being steamrolled by the majority. In the real world, though, this test is incredibly difficult for a minority shareholder to win. The courts don't ask if the change was actually good for the company. They just ask if a reasonable shareholder could have thought it was good. That's a huge difference, and it basically gives the majority a massive amount of wiggle room to do what they want. And that brings us to our final section. After all these years, after all these court cases, many of these fundamental power struggles are still legally up in the air. So let's take a look at why the law is still so murky. You can really see the mixed bag of results when you look at attempts to reform the law. Sure, some things got fixed. For instance, they got rid of the rule that private companies had to hold an annual general meeting. That was a successful reform. But other really important changes, like forcing big investors to disclose how they vote, were totally rejected. And as we've seen, that central confusion around the Section 33 contract was left completely untouched. The story of that failed Section 33 reform is just a perfect example of how things get stuck. A major legal review group clearly identified the problem. The law is a mess. They proposed a simple, clear fix. Just say that members can enforce the rules against each other. The government even consulted on it. And then, crickets. The Big New Companies Act in 2006 just reworded the old confusing law and basically kicked the can down the road, leaving the courts to keep struggling with it. So, after diving deep into this hidden world of corporate power and unwritten rules, we're left with a really big question. When a company's constitution is designed to be this flexible, and the power to change it all lies with a 75% majority, who does the law really end up protecting? Is it the company itself, the majority shareholders, or the individual? It seems like, even after all this time, the answer is still being written.